All right. Good evening, everyone. Thank you for joining us tonight for this stakeholders meeting entitled Post-Public Health Emergency Evictions and Tenant Protections in the District of Columbia. We're pleased with the attendance this evening, and we look forward to having an informative discussion with our panelists. Our panelists are composed of subject matter experts that will cover the eviction process from the courtroom all the way to eviction day, as well as the public health emergency and post-public health emergency legislation. With us this evening is the Office of the Tenant Advocates Policy Director, Director Joel Cohen, Ms. Lachey White, Branch Chief of the Landlord-Tenant Branch of the District of Columbia Superior Court, Chief Deputy Sebastian Barrois of the United States Marshal Service, Ram Upaluri, Committee Director, Councilmember Bonds, Blaine Stum, Legislative Policy Director for Chairman Mendelson, Ms. Maya Brennan from the Office of Councilman Silverman, and Amanda Korber from the Legal Aid Society. Before we begin, I would ask that while we are listening to the panel discussions, that we keep in mind three main takeaways. The first would be a procedural takeaway, which is in the District of Columbia, a tenant cannot be evicted without a court order signed by a judge, executed in the presence of Deputy United States Marshals. The second is a policy takeaway, which is before a tenant can be evicted in the District of Columbia for the non-payment of rent, the landlord must seek rental assistance. And the third is an outreach takeaway, which is basically knowing where to turn to. If you need help paying rent or utilities, please apply to Stay DC at stay.dc.gov, or you can call 833-478-2932. And if you need legal assistance, please reach out to the L&T Legal Action Network at 202-780-2575, or the tenant hotline of the Office of the Tenant Advocate at 202-719-6560. Throughout the presentation, we will be monitoring the chat box, and we will be selecting questions from the chat box to be asked to the panelists during the question and answer portion. Having said that, I'll pass it over to the Office of the Tenant Advocate's Policy Director, Director Joel Cohen. Thank you.
Okay, thank you, Cristobal, and good afternoon and welcome everyone. Again, this event is entitled Evictions and Tenant Protections in DC after the public health emergency. A year ago, the OTA held a forum with the Office of the Attorney General entitled Evictions Preparing for the Storm. At that time, it was widely anticipated that many tenants would continue to be hard hit economically by the COVID pandemic. Many tenants still unable to pay the rent owed would be at high risk of losing their homes. As of a few weeks ago, 40,000 renter households in the district are still at risk of eviction, 14% are not caught up on rent payments, and 23% have no confidence or only slight confidence in their ability to make next month's rental payments. At the same time, the district has received $352 million in federal funding to help tenants pay off pandemic-related rental and utility arrearages. The district-wide program, Stay DC, has been set up to help connect tenants and landlords to that federal funding, and the mayor has signed into law legislation which phases out the eviction moratoria, but at the same time conditions eviction actions for non-payment of rent on landlord as well as tenant applications for that rental assistance. The purpose of today's program is to explain what tenants need to know about evictions and eviction protections now that the moratoria is in fact being phased out. For the run of the show, we have divided the program into three sections. First, an evictions process and procedures panel. Second, a policy panel to discuss the phase out legislation and any policy concerns that may still need to be addressed. After these two panels, I will hand the proceedings back to Cristobal, who will moderate an education and outreach panel. Each of our 6 panelists will have, in the first two sessions, will have up to 5 minutes to present. Our goal is to save 30 minutes for Q&A after all 3 panels have been presented. So please put any questions you have into the chat box as they occur to you. Cristobal will direct them to the appropriate panelists after all 3 panels are finished. I'm going to start things off, segueing into the process panel with some eviction basics. These are the eviction protections that DC tenants have had for a very long time and continue to have. First, the landlord may evict a tenant only for one of 10 specific statutory reasons. Unlike other jurisdictions, for example, a tenant cannot be evicted just because the initial lease term has expired or the property is foreclosed upon. The landlord may not use self-help methods to evict a tenant. Rather, the landlord must go through the judicial process, and the tenant must be given the opportunity to challenge the landlord's claims in court. Finally, any eviction must be pursuant to a court order and must be scheduled and supervised by the U.S. Marshals Service. So with that, we will now turn to our evictions process panel. As Cristobal mentioned, they consist of Lachey White, who's the branch chief at Landlord and Tenant Court, and Sebastian Barois, who's an assistant chief deputy U.S. Marshal at the U.S. Marshals Service. And Lachey, we'll start with you.
Good evening. Thank you, everybody, for having me here. I appreciate the opportunity to share how DC Courts has been operating throughout the pandemic. First, I want to share that we have remained open since the beginning of the pandemic, and we continue to be open. And we have resumed operations Monday through Friday on site with a limited staff in Building B. And that address is 510 4th Street Northwest in room 110. There are multiple ways that people can reach out to us. They can do that by calling us on 202-879-4879. They can reach us in person. They can use our chat line by going to dccourts.gov and then going to the Superior Court tab, followed by Civil Division, Landlord, and Tenant. I also want to share, before I go into the details of the process of what happens when you file a case, that we are addressing emergency matters. Those are being addressed by the judge in chambers, and you can contact us by email to submit any emergency requests that tenants are having, such as no water or no heat or no air conditioning. So they can email us at civilefilings@dcsc.gov. Also, if any tenant is struggling to, any tenant who needs to pay any filing fees, but they're struggling and they don't have the income, you can apply for a cost waive application, and you can email us using that same address that I just provided, and we will get that approved as quickly as possible, and then go ahead and file your documents. So I just want to repeat that address again. It's civilefilings@dcsc.gov. I'm going to use this and segue directly into what happens when you file a complaint. The cost is $15. Once the complaint is filed, right now we are not scheduling any initial hearings for any complaints that were filed on or after March 11th of 2020. However, due to some moratoria changes, we are scheduling only those cases where there is a drug haven and or is subject to the public safety exception based on the existing moratoria. Those cases are being scheduled and going before a judge. Additionally, all hearings in the civil division are being held remotely. So when a case is scheduled for a hearing, we are sending notices of the hearing to all parties, and those notices include instructions for how to participate virtually or telephonically in the hearing. We also have 5 different satellite offices throughout the District of Columbia where people can make an appointment in advance to use the computers there if they don't have internet access, and that way they can still participate virtually in a safe manner in the hearing. And I will give the number to the satellite offices if anyone is interested in that. That number is 202-879-1900. And then after this panel is over, I'll send all of the contact information that I'm sharing to Mr. Cohen. I'll make sure that their team has it and they can share it out as needed. I also want to share, so all of the hearings are being held virtually. We are processing writs of restitutions where judgment has been entered, and we are forwarding those to the U.S. Marshal's office. Right now, until the court addresses the most recent legislative changes that have taken place, we are not sending writs. We haven't sent any as of yesterday, and we continue not to send them today. We continue to process them, and we are holding them until the court finalizes its decision on how we will proceed and handle the different constant changes that are coming out from the council. Also, we have a drop mailbox on site here in Building B. You don't even have to go through security or get your temperature taken if you simply want to use the drop box to drop off something to be filed. There is a time and date stamp right as soon as you enter the building to the left of when you enter through the doors, and you can drop off your filings, and the date and time of your filing will be honored when the clerk processes your document. Or we still have a drop mailbox in the main building at 500 Indiana Avenue on the first floor. I also want to share that we are accepting protective order payments. Those protective order payments can be made online up to $1,000 every 30 days, as long as your protective order payment does not exceed that amount, okay? All you need to do if you want to use that online payment service is contact the clerk's office via email at landlordandtenantdocket@dcsc.gov, and the clerk will respond with a link that expires after 3 days. After 3 days, if the tenant does not use that link to submit the protective order payment, it will expire and you'll be required to start the process all over again. So the links have an expiration, or you can come on site and make those payments, or you can mail a check or money order. Of course, if you're paying in cash, you need to come in person. I do want to make everybody aware that we recently have some changes to our check policy. And so if you are paying by a check or a money order, the check needs to be made payable to clerk of the courts, okay? Clerk of the courts. It's no longer clerk DC Superior Court. So please make that adjustment if you are paying by a check or money order. I also want to share that due to another financial change that we've had in the organization, that anybody seeking to have funds dispersed from the court registry, those funds will not be released if anything was paid by a personal check until 2 weeks after. That gives us sufficient time to make sure that the money is really in the registry and wasn't returned by the bank for any reason. I also want to share with tenants that if anyone has any housing code violations, they should submit those filings to the Civil Actions Branch to submit that filing. And that can be done online using the Law Help Interactive website. I'll send that website to Joel after the call. And I think that's all that I have. There are subsequent hearings taking place, such as different motions for various things. All of those hearings, just like anything else right now, are virtual as well. And that may take me to my time, Joel. You can let me know if I exceed.
It does. You're a little bit over time, but that was great information. So thank you, Lachey. I appreciate it. And Sebastian Barois is the Assistant Chief Deputy U.S. Marshal at the U.S. Marshal Service. You're up next. And if you can attempt to be within the 5 minutes, that would be greatly appreciated. We have a tight schedule today. So
no, I'll do my best to keep it within that time frame, John.
Thank you.
So anyway, thank you again for having us here as well. Like I said, I'm Sebastian Barois, the Assistant Chief of Superior Court. Myself Eric Navis and Brad Coleman, the two supervisors who oversee the service and process, are also present. Let me start off by saying to everyone that while we often see on the streets arresting fugitives, our goals and mission when conducting eviction is taking a calm and even-tempered approach. All right, I say this because it is very important to distinct the two different aspects of our missions. And often, like I said, we're seeing out there on the streets with fugitives, and this is not the same tempo. We're here to assist the courts with executing writs of restitution filed by landlords/plaintiffs. We make every attempt to proceed with an understanding that evictions are very impactful to families, emotional in nature, and therefore sympathize with their current situations, and a level of diplomacy is key. However, we also have the job to perform and must protect ourselves from unforeseen circumstances. Therefore, it is common practice that our deputies will wear protective equipment with U.S. Marshal markings to include masks. Because of COVID now, we're forcing everybody to wear masks, so there shouldn't be a concern for people being exposed. But don't be alarmed by this. It is simply to make everyone aware of who we are in the community and provide safety measures to our deputies who are in the field. We hope that some of the information we're going to provide tonight will help answer questions and ease tenants during this very stressful time. So I'll first start off by saying that we are, like Ms. White said, we've had received, but now we're not receiving. So we are also awaiting some guidance from the courts. But some of the things you can expect from us is one, we always send out mailers to the tenants. The language for the mailers now will be modified to indicate their new eviction date. And inside the package that we send out, you will receive a copy of the actual court order, the writs. It will have a start and expiration date. You will have some instructions of what to expect from us before we arrive. The actual date of the eviction that has been scheduled. And then the notice instructs the tenant to remove all property before the scheduled eviction date. That's kind of important for tenants to know because it makes it a lot easier for us to turn over the property to the landlords before we get there. And that's why the notice is somewhat important, because you will get a notification of when we're coming. So it's not like before where we used to just show up and then remove all the property. Now you are given a decent amount of time before we come. The other thing I want to mention is we no longer place property on the streets. That was an older system. Now we have a new system in place. It's a lot more effective. It's a lot friendlier that way. It provides safety for people's personal information instead of things being put on the streets. So just kind of a reminder to everyone who have not gone through this process, no longer are we placing any property on the streets. Once deputies arrive to carry out the evictions, we will offer the tenants an opportunity to collect valuables. Now, this means, you know, you have a few minutes to either get your wallet, your cell phones. Obviously, if there's children involved, we allow for people to get clothing, formula, or Pampers. But just be mindful that we are not going to let everyone be in the house for the next 30 to 40 minutes to get their belongings. We try to do this as speedy as possible and try to get everybody out. The other thing that we perform is a security sweep to protect everyone in the house and to include ourselves. And we want to ensure that when we do come to the eviction, that everybody is safely removed from the property. The other thing that I want to address that sometimes becomes a concern is pets and animals. If you have pets, please make sure you try to find accommodations before we get there. Otherwise, when we get there, we are forced to call the DC Humane Society /Animal Control, and they will come and remove the animal /pet. So just keep that in mind. If you do have pets in the house, try to find a method of having them not at the house when we arrive. We talked about potential different types of writs. One of the key things that was mentioned before and that we want to try to highlight to everyone is there are possession-only writs, which basically means that we are taking the property even if the tenant is able to pay. If it's not a possession-only writ, or if it doesn't say house on the writ, then the tenant has the opportunity to pay the remainder of the balance to the landlord. Now, we don't have anything to do with the actual transaction of exchange of money, but we are there to make sure that if it is going to happen, that it's done accordingly. And the methods of doing it is either cash, cashier's check, and a money order. So those are things to be mindful. Like I said, we ask that if you are able to pay, that you do it probably on the front end. But if it happens that we show up the day of the eviction and you have the money at hand, we will facilitate that transaction with the landlord. Lastly, the one thing that is probably not common in the summer, but will probably be happening in the winter, is postings. We post evictions based on the weather and other impairments. So for example, if it's raining out, by the time we arrive to the property, we will post the property saying that the eviction is ongoing, and then we will come at the next available time. The same as if the weather is 32 degrees, if it's cold, we will post the property and come back at a later time. There have been instances where we've had families with family members that have been bedridden. So we talk to the court about it, and a lot of times we post it, and then we try to make sure that they have accommodation to remove the individual from the property. Those are the key things I think are important for all tenants to be aware when we arrive. And that's pretty much it.
Great. Thank you so much, Sebastian. Great information. So we're now going to turn to our policy panel, and we're going to start off with Blaine Stum. Blaine is the legislative policy advisor for the Office of Council Chairman Phil Mendelson. And Blaine is going to provide an overview of the recent legislation. Blaine, you're on.
All right. Well, thank you, Joel. And I appreciate being able to be here. And thank you to all who are in attendance. I'll start off just by giving folks sort of a recap of what happened and then go through the bill a little bit, just so that way folks know sort of where we're at right now. So the council considered a bill to phase out the eviction and utility moratoria on July 13th. The council approved the bill unanimously, and it was signed by the mayor on July 24th. She had to sign it before July 25th because that's when her public emergency and public health emergency powers expired that we had extended in other bills. So it is currently law, and I'll take you through sort of just an overview of what it does so folks know sort of what to expect and in terms of policy. So the bill, there's only two exceptions right now to our broad eviction moratorium. One is for tenants whose presence is a current and substantial threat to the health and safety of others. That can be other residents, property owners, people in adjacent properties. The acts of sort of what constitutes a current and substantial threat include like acts of assault, unlawful possession of a firearm, or threats or acts of violence, which are defined in the statute. And if people have questions, I'm happy to speak to that. The other exception is for significant property damage. And in this case, tenants can only be evicted or have a case filed against them if the landlord can demonstrate that the tenant willfully or wantonly caused significant damage. So that means if you had like an accident, and broke something, like that's not going to fall under that exception. It would have to be something that was done maliciously and purposefully, and it has to be significant. So it can't be like a tiny little scratch or a dent. It needs to be like large holes in the wall, destruction of appliances, plumbing systems. Like it needs to be something that's pretty significant. So those are the only cases that can be filed right now. Outside of that, landlords will be able to file non-payment of rent cases at starting October 12th at the earliest. The non-payment cases must be at least $600 or more in rent owed. So if it's below that threshold, then they couldn't file. And in order for a landlord to file in court on October 12th, they would had to have already given the notice of past due rent, which I imagine Maya will be speaking to in a minute, as well as a couple other notice issues. They also have to apply for rental assistance on behalf of the tenant or initiate the application, then notify the tenant of the application and wait 60 days before filing. The 60-day sort of window was given because we know that it takes anywhere from 30 to 45 days, sometimes longer, unfortunately, for applications to go through the review process in state DC. As I think Cristobal or Joel mentioned earlier, the district got around $350 million from the federal government in emergency rental assistance. And so we want landlords and tenants to access that money so that way we can get those debts paid, make sure that the tenant doesn't get evicted, and make the landlord whole. And that's sort of why we wanted to tie the non-payment of rent filing to have you actually applied for rental assistance beforehand. If the landlord fails to do any of these things, the case has to be dismissed. So if they file and they can't show that they applied or they didn't do so in good faith, then the judge has to dismiss the case under the legislation. Additionally, if an application is pending, so like let's say you've submitted something, that 60-day window is still there and it's still under review, or it's been approved and awaiting payment, or you appealed a decision, maybe they denied you for some reason, the case has to be dismissed there too. And the tenant can demonstrate that really easily. We tried to make it so that way we didn't put the burden on tenants to have to do all of this work because landlords are the ones who are wanting to evict people. And so we wanted to make sure that the onus was really on the landlord to go through the process of applying for rental assistance and also making sure that that was done in good faith and there was an actual effort to get that money out. Now, as I noted, those cases can begin on October 12th, or they can be filed on October 12th. All other eviction cases not covered under the exceptions that I mentioned earlier for public safety or property damage, and then not related to non-payment of rent, those can only be filed beginning January 1st, 2022 at the earliest. So anything that like is a violation of like a lease, for instance, like let's say you have a lease term that you violated, maybe you didn't know you violated it, or you did, and the landlord wants to kick you out because of it. They couldn't actually file anything until January 1st, 2022 at the earliest. And they would have to go through all of the processes and procedures that are required under district law in order to do so. And I think I'll leave it there. And then if anybody has any questions afterwards, happy to answer.
Great, wonderful. Thank you so much, Blaine. Next, we're going to go to our landlord and tenant court practitioner on the panel. Amanda Korber is with DC Legal Aid Society. And Amanda, the mic is yours.
Thanks, Joel. I will try to be brief, and I'll just build off a couple of things that Blaine was just talking about. So the first thing that I would emphasize to folks who are behind on rent and worried about facing eviction is to apply for state DC. And if you're having trouble applying for state DC, because I think, you know, we all know and have heard about the challenges of getting through that application, to reach out for assistance in getting that application in, because as long as it's pending, even, you know, after October 12th, as long as it's pending, your landlord won't be able to file a case for non-payment of rent against you. So I think that's kind of just a really important thing to keep in mind. And then the second thing I will highlight is a group of tenants that is a limited universe of tenants, but is important because they actually, when the public health emergency expired on July 25th, they lost basically all local protections. And that is tenants who had eviction cases filed against them before the pandemic started and had those cases go to judgment already. And those folks are at risk of actual eviction now after receiving a 21-day notice of an eviction date or a 30-day notice of an eviction date, depending on a couple of circumstances. And so for the first time, though, DC is in an interesting spot where for the first time, we actually, for that specific group of folks, they are actually more protected by the federal CDC moratorium than by the local DC moratorium. And so for those folks facing actual eviction, they may qualify for the CDC's protections. And there are a number of factors that determine whether a person qualifies for the CDC's protections from actual eviction. They include having an income at or below, I believe it's $99,000, having made good faith attempts to apply for rental assistance and to pay rent to the extent they've been able to, even if it's partial payments, and have been impacted by COVID, had their income impacted by COVID. And for those folks, there's a declaration that they should fill out and give to their landlords as soon as possible. I do want to note that the federal moratorium is the subject of legal challenge. So while it's really important, if you qualify, to fill out that declaration and get it to your landlord as soon as possible to ideally and hopefully delay any date on which you can be evicted, it's possible that law will change as it kind of goes through the courts. And so I would just say, keep an eye on it. If you have any questions about whether you are entitled to those protections or whether you can or should fill out the declaration, I would encourage you to reach out to a landlord-tenant lawyer. You can reach the Landlord-Tenant Legal Assistance Network at 202-780-2575. And you can get connected to a tenant practitioner who should be able to help you figure out if you should be a person who fills out this declaration and gives it to your landlord. I think, Joel, if it's all right with you, I will leave my remarks there and I can turn it over to whoever's next.
Under 5 minutes. Amazing. Well done. Thank you, Amanda. And next up is Maya Brennan. Maya is the policy advisor for at-large council member Alyssa Silverman. Maya, mic is yours.
Sure. Thanks, Joel. I'm going to try to run through things pretty quickly about notices, but feel free to ask any questions later or get in touch with me. My email address for the council is mbrennan@dccouncil.us. So the legislation that Blaine had talked about changed a couple of things specifically about notices that a tenant can receive. So right now, a tenant can legally get two types of notices that relate to eviction. One is a 30-day notice to correct or vacate for those very specific cases that Blaine mentioned about violence or substantial property damage. And the other is a newly created notice called a past due rent notice. So the exact language for this notice was written into the law. The notice has to tell you how much rent is past due. It has to include a rent ledger. It has to give 60 days to submit an emergency rent assistance application, such as Stay DC, and it has to tell the tenant that they do not have to move. It will specify the terms under which a landlord could file if a tenant does not actually submit that application in that 60-day period or gets denied for emergency rent assistance. If one of those things happens, then the landlord could, in fact, file after October 12th, or if at least 60 days have passed since they gave notice. The other type of notice that can start is a notice to vacate on, for any other reason, could start as early as September 26th. That's 60 days after the end of the public health emergency. That could be a notice to vacate for any other types of breach of lease. It could be a notice to vacate because the property owner wants to move back in or for any other legal cause. Those notices are valid and should be taken seriously. They give a variety of different lengths of time, but what you should also be aware of is that the notice itself is the first part in the process. The owner cannot actually file to get the court to enforce that notice until at least January. So you may, again, September 26th or after, start getting notices for other reasons that a landlord wants the property back. And you should take those seriously, but get some legal information or advice if you have any questions about whether that is enforceable or not and what you can do. In thinking about having these sorts of notice requirements and in what we want it to do around the broader phase out, Blaine, myself, others involved in the council and advocacy communities, we're looking at a variety of different places as models. But one thing that I think is interesting to note is that for the notice process, we actually looked internally, but at different aspects of the law. So we looked at the DC wage garnishment law that provided a good precedent about legislating specific notice language to make sure that in a case that is pretty severe for a person's life and livelihood, that notice is very clear. So at this point, we're really watching for a couple of things about the future policy situation related to notices. Does this really work? Does this newly legislated notice process provide enough clarity, provide enough option for landlord recourse? What are we hearing needs to change? And could it be potentially a change to the future process so that a new non-payment process in the future may start with this notice of past due rent and a requirement to wait to see if a tenant can get emergency financial assistance before filing. We may have some other things to look and watch out for, but I think Ram will have a lot to say about that. So I will stop right there.
Great, thanks so much, Maya. And next up, Ram Upaluri. Ram, I hope I'm pronouncing your last name correctly.
Yes, thank you.
Ram is the committee director for the Committee on Housing and Executive Administration. And Ram is going to round out the discussion with any further thoughts about the phase out legislation and what is on the committee's mind for after the summer recess for the council.
Right. So these were excellent presentations that came before mine that I think went into a lot of technical details that I thought were, very thorough. And I think the staffing on these provisions has just been excellent with, Blaine and Maya and a group of other staffers here at the council and gathering input from the advocacy community. So as far as the legislative process and, how the housing committee, we're now called the Committee on Housing and Executive Administration, chaired by at-large council member Anita Bonds, will proceed. I just wanted to kind of sketch out how I think our activities will unfold when we come back from our recess, which we are currently in for all purposes other than the budget or any emergencies that may arise directly as a result of the, the pandemic, the health. Any health-related matters may be taken up at the next legislative meeting on next Tuesday, which Blaine is busy preparing for. That will basically be the last legislative action that the council takes prior to like a fairly long recess. We won't be back until really October 1st. The recess runs through September 30th. And what that means is through September, we won't be introducing any new bills. We won't be holding any hearings except for certain very limited purposes. And, we're not going to be having any markups. We're not going to be moving any bills, but we will be preparing to come back in October, I think with some legislative matters that are of interest to this group. So one is that we currently have in place on a temporary basis certain protections for tenants at the end of eviction proceedings. So there's a record sealing provision that's in place right now and some other tenant screening protections that are in place under a temporary bill that is set to expire on October 27th. It is our intention to renew those measures on a permanent basis. So we've held a hearing on those bills this year and would like to move to marking up those provisions as soon as we come back and having them go into effect right away so that they continue as you begin to see these cases start to move through again. We would like to see at a minimum the protections that we currently have in place in terms of people's court records being sealed and in terms of what can be used for tenant screening purposes by landlord. We'd like to make those permanent. So that's really one of the first steps that we're going to take when we get back, and certainly, you know, welcome your all's involvement in those efforts. Just a couple of other things that I think we're likely to see coming back in the fall. We'll be keeping an eye on TOPA tolling. And I know that sounds maybe a little bit technical, but we're expecting, I saw a note from the affordable housing community earlier today that suggested that as many as 100 properties could come up for sale. And the coming out of the pandemic, triggering a 45-day opportunity for tenants to put together purchase deals and remain in their housing, so at affordable rates. Those deals are complicated. They require a lot of technical assistance. Councilmember Bonds managed to get an additional $1 million in technical assistance support funded at the Department of Housing and Community Development that will go out to CBOs that are involved in providing that type of technical assistance. And so we'll be keeping a close eye on that. Blaine and Maya have mentioned that the eviction filings resume as of October 12th. Other eviction filings will resume as of January 1st, 2022. We are expecting to have some conversations about vacancy rates, keeping an eye on opportunities to lock in rent affordability or rent stabilization. We'll probably be holding a hearing on a bill called the Generating Affordability in Neighborhoods Act of 2021, the GAIN Act, introduced by Councilmember White and Brianne Nadeau. It's already been funded in the budget, but the legislation itself hasn't been enacted. So we're planning to schedule hearings on that bill and try and move that one to markup this fall. So I think my time is up, but just by way of saying we're going to be very active on the legislative front, keep an eye on the calendar, and as always, we will welcome your input and participation in our hearings, and to help us get to better products. But I anticipate that the fall is going to actually be quite busy preparing for what may be a radically transformed landscape coming out of the pandemic and moving into 2022.
Great. Thank you. Thank you so much, Ram. And thanks to all the panelists. That was very good information. I'm going to hand proceedings over to Cristobal, but first I'm going to remind folks that if you have a question, please post it in the chat. Now is the time to do it. Right after the education outreach panel presents, we're going to be going to Q&A, and we'd love to see that chat box fill up with your questions and get to those first and foremost. Cristobal, it's yours.
Thank you, Joel. So now we are going to the outreach panel. The first panelist is going to be Mr. Malik Williams. He is the Deputy Chief of Staff at the Office of the Deputy Mayor for Planning and Economic Development. He's here to give us an update on Stay DC outreach activities. He will be followed by Nicole Mackenzie, who is the Education and Outreach Program Analyst here at the Office of the Tenant Advocate, and she will also be providing an update on OTA outreach activities. With that, Mr. Malik.
Thanks, Cristobal, and good evening, everyone. Thanks, OTA, for pulling this together, and good to see all of you on here. So wanted to just give a quick overview about Stay DC outreach. So the district, we have kind of a multi-pronged approach We have our DC government agencies that have been equipped with state DC outreach toolkits, information that are getting the word out via their outreach teams, as well as the vaccine buddies, vaccine ambassadors that you've seen throughout the city. They also are equipped with state DC information and are engaging residents about that. And then we have CBOs, particularly that have contracts with the Department of Human Services, as well as the Department of Housing and Community Development, which are helping people apply in person. They're offering in-person application assistance as well as outreach also. And they have been conducting some events in specific buildings that they have connections to as well. And then the third prong is the district's kind of DC government, the state DC ambassador team. Some people may have seen them. They have their green t-shirts on. And they have actually been rotating pop-up application assistance events, primarily at libraries and recreation centers. Some in partnership with DC Health at the vaccine giveaway events that have been happening as well. And so that team, the DC outreach team, state DC outreach team, is having at minimum 3 events, 3 pop-up application assistance events per week. Sometimes they're more, sometimes they're every day of the week, but at minimum, we have those dedicated Tuesday, Thursday, and Saturday dates. Some people may be familiar with the events calendar that we have up on the State DC website that lists these pop-up opportunities from the paid team as well as the community-based organizations as well. So there's kind of a full calendar on state.dc.gov/events. And I'll try to drop all these in the chat, all these links in the chat when I stop talking, where anyone, residents, landlords, community organizations, they can go and see where the opportunities are to get that in-person application assistance. The other kind of points that I would want to highlight kind of specifically around additional DC government agencies, the Department of Housing and Community Department of Housing and Community Development, or DHCD, also is offering in-person application assistance and via their Housing Resource Center. So they have 10 computers set up in there, printers, scanners, where residents are able to come in and apply there, as well as get some coaching and assistance. And then also the Mayor's Office of Latino Affairs is doing the same. So they have their team and their staff that are helping residents or helping tenants apply for Stay DC. That's Monday through Friday. And they have after hour opportunities to get that coaching as well. And so obviously they can assist residents that are Spanish speaking, but it's open to every resident as well. So it's not just stricken to that. So I did want to highlight those two also. And then just to talk a little bit more about kind of where we are and how we're meeting people. So on top of those 3 in-person application assistance events, the team is out Monday through Saturday, pretty much all day, engaging with folks. So we're using obviously data, census tract data, application data that we're getting to see where we need to be, where we need to put the team. And so they are hitting high traffic and engagement areas, metro stations, grocery stores, food distribution locations, and then also particularly around those high density rent buildings that we know, and then also housing authority properties. And so that's every day. And then just highlighting those Tuesday, Thursday, Saturday events that will happen every week. And then just in terms of, we've gotten some questions since we've been out in the field helping people about, from particular residents that are helping get the word out about the events that we're doing, about what they need to communicate to tenants to bring. Obviously, we've communicated to them if they have documents to bring those. We're not accepting those documents, but we're scanning them into the application, which they're helping to do on computers and tablets. And then, so yeah, that's pretty much all we're telling people that they need to bring. If they don't have them, obviously there's the self-attest option. And so that's what we've been communicating in case people wanted to know what they should bring or what they should be communicating to tenants to bring to these pop-up events. And so again, I'll make sure to drop those links in the chat just about where those events can be found. And then also I'll drop in the chat just a link to the resources page that has some of the critical documentation that's translated into all of the languages that are required in the District of Columbia. So with that, I think I'm a little bit over my time, but I'll stop there.
All right, Nicole Mackenzie will now give us an update on the OTA's outreach activities. Thank you, Nicole.
Thank you. And I am going to share my screen. So I'm Nicole Mackenzie. I work with Chris in the Education Outreach Department of the Office of the Tenant Advocate. And one of the big takeaways that we want everyone to get from this, there's been a lot of information, obviously, presented tonight, but we really want to make sure that people understand where they can get help. Obviously, State EC is one of those options, but the Office of the Tenant Advocate has been doing outreach both in person and online throughout 2021 and the pandemic. So despite, things sort of slowly opening up and sort of concerns about the Delta variant and things like that, we have been reaching people in person and we have been attending events safely, especially outdoor events. So we wanted to showcase the ways we've been doing that and the ways we've been spreading the word that our office is available to help tenants for free. So first of all, virtually, we obviously have been taking advantage of virtual communication throughout the pandemic, not just in meeting like this and doing other Zoom meetings, but, we're also doing trainings online. So we've attended 31 trainings on tenant associations or renters' rights in 2021. We've been hosting those. We've attended 15 ANC meetings in targeted wards, so in wards 1, 4, 7, and 8 in 2021, and we aim to try to hit all ANCs if possible by the end of the year. And that's really been made possible through Zoom and through having virtual meetings. It makes it a lot more achievable to be able to reach each ANC. Our social media presence has more than doubled over the course of the pandemic with followers and posts. We're reaching people on Twitter and Facebook most effectively. And we also have a bank of YouTube videos and tutorials available for tenants to watch if they're looking to have questions answered as well. We've partnered with Carison and recorded Renters' Rights 101 trainings in Spanish. And we've partnered with the DC Office of African Affairs, French-speaking African Coalition, and recorded our Renters' Rights presentation in French as well. So in addition to virtual outreach, like I said, we're doing tutorials as well, where tenants can essentially have their most frequently asked questions answered immediately. So rather than calling our office and sort of having to wait for someone to peruse their lease, if they have a quick question about mold or a question about whether their landlord can enter their apartment with little notice, they can have those questions answered through these tutorial videos. And then, of course, in-person outreach is something we've still been taking advantage of despite the pandemic. Primarily, we've done that through flyer distribution, A-frame signage in high traffic locations, and events. So flyers, we have distributed over 6,000 flyers and counting with organizations, especially organizations that focus on food distribution, because we found, obviously, during the pandemic, a lot of people who are experiencing food insecurity are also experiencing rent insecurity. And many people were forced to choose month over month. Do I pay my rent this month, or do I, pay for food and pay for essentials? So we targeted those specific organizations and places that were doing food distribution because we saw that those would be sort of the best way to reach people in need in that sense. So some of our partners include DC Central Kitchen, the Feed the Fridge program, Mary's Center, Catholic Charities, Clínica de Pueblo, District of Columbia Public Schools, and public libraries. And then and also, in addition to the food distribution, we've done canvassing with, going door to door, essentially, to local businesses, churches, community organizations, again, in targeted wards, to make sure that our flyers are available and visible on essentially every bulletin board that we can find, and in store windows as well. So, if you know of a business that needs a flyer, please let us know and we will get it out there. Additionally, we've had signage, especially A-frame signage, like you see kind of like a sandwich board sign in high traffic locations, especially initially the DC Health COVID testing sites. We had our signage there before those sites sort of transitioned to become vaccination sites. And that was a huge reach for us because they were experiencing high traffic on a daily basis, and this was a great way for people who were likely tenants to be able to see us and know that we were there. Similarly, we have signage out at the District of Columbia public libraries and parks and rec centers. Even the convention center, we had signage there. So again, really high traffic locations with big, wide sandwich board signs that you can't miss. And then of course we've attended events. So there have been some in-person events outdoors that we've been able to attend, and we're very happy to have done so. The Far East Collaborative Community Resource Fair, the Woodbury Tenant Association Community Fair, Cardozo Family Fun Day, TA meetings, Carver Langston Family Day, and the DPR Roving Leaders Day. So we've experienced really effective results from doing those in-person meetings and really meeting tenants face to face, and where they're able to tell us about their problems, and we can tell them a solution, which is, contact our office and we can assist you with this. So we're counting essentially the number of outreach events we've been doing over the course of the year, and we've had over 100 in 2021 despite a pandemic going on, which we think is great, and we're still counting. So about halfway through the year, we hope to double that by the end of the year, and we hope to continue doing both in person, safely, socially distanced, and preferably outdoors, as well as Zoom communication, which seems to be really effective, especially with, A&C meetings and some other meetings as well. So if you or your organization would like to schedule OTA to present, either a renter's rights training or a tenant association training, or any sort of training to your group, please let us know. And also, if you know of a business who needs a flyer or a sign out front, please contact us. We're trying to spread the word, and you can help. So you can reach us either on our social media handle, which is at OTAATDC, or our website, ota.dc.gov. Yeah, and so thank you so much for watching our presentation, and I'm going to throw it back to Cristobal, I think, for our Q&A session.
Outstanding. Thank you, Nicole. Thank you, Mr. Williams. With that, that brings us to the question and answer session. So, Joel, would you like to ask the first question?
Sure. I'm going to let me adjust the phone here. So I'm going to start with a point that Lachey made, which is very important. Lachey, I believe you said that there are two types of cases currently being heard: landlord and tenant court, the drug haven law, and then also the public safety threat of violence. Did I understand that correctly, Lachey?
Yes, I was struggling to get the mute button off. But yes, those cases are being scheduled, anything that's under the public safety exception, and that includes extreme property damage. So not just a safety or violent issue going on, but also if there's extreme property damage taking place, those cases are being scheduled for hearings. And also drug haven cases are being scheduled.
Okay, and I have a number of questions about that actually, and I suspect folks in our audience do as well. With regard to the drug haven law, those cases are really separate and apart from evictions under the Rental Housing Act. And so does this mean that those cases have been heard all along during the pandemic?
I am not positive, believe it or not. We have had a number of changes with different things that we have been scheduling. and not scheduling, but I want to say that we have, because normally we schedule those cases for 2 weeks out, but I'm not positive.
Okay.
But those are with the safety violation cases, the drug haven cases are.
Okay. And I'm going to ask if Blaine or Maya can weigh in and confirm or correct. I believe that the PHC eviction protection laws have amended only the Rental Housing Act and not the drug haven, so that those cases rightfully, lawfully could proceed. And Blaine or Maya, do you want to speak to that category of cases at all?
I was going to defer to Blaine, but it looks like he's trying to defer to me. So my understanding is that the writs were all writs, but that the filings was in just the Rental Housing Act. But Blaine, feel free to fix me.
No, that's my understanding too.
Okay. I started to throw a curveball there, but I try to tease that out of my own head first. Amanda, I suspect you might be the best person present to speak to drug haven evictions.
Yeah, so I was going to say that actually was an open question of law. I don't think anybody mentioned this on the call today, but earlier in the pandemic, there was a Superior Court case where the judge considered whether the filing moratorium was constitutional or not. And he selected sort of a swath of cases that were different types of cases. And one of those cases was a drug haven case. The lower court judge decided categorically that the filing ban for all cases, not just specifically drug haven cases, was unconstitutional. But then it went up on appeal, and that decision was stayed by the appellate court, and it's still kind of in the process of being decided. So, I think there was arguments on both sides for the filing ban generally, but also as it applies to drug haven cases. And my understanding was that for at least earlier in the pandemic, before there was a public safety exception, those cases that were filed, those drug haven cases that were filed during the pandemic didn't go forward and were stayed pending appeal.
Okay, thank you. Thanks, Amanda. My other question about your point, Lachey, is that the public safety exception has actually been a part of the PHE law, I believe, since April, whereas the property damage exception is new in the legislation that the mayor just signed. And when you said those were the two cases being heard now, I assumed that meant that notices were actually getting to tenants and expiring, and the action could then proceed in court in those two categories as of now. For the public, now you've just mentioned that the property damage category kind of conflates with the public safety exception, but I assume that notices are going to need to get to the tenants, and that the court has not yet received and maybe should not expect to receive filings until that notice period expires. I hope that question makes sense. And Lachey, can you speak to that at all? And I'm not asking for the legal opinion, I'm asking.
Yes, that is what you just said is correct. So there was an administrative stay, and as we have recently, due to these changes that have taken place, that we're receiving those cases, they will be scheduled. But those cases, I'm not aware of any actually going but for the judge yet, but we are going to schedule those cases. And with us, we adopted a policy even before the pandemic. Any hearing that is set and scheduled, notices go out to all parties. Since the pandemic, we've taken that a step further, and we mail out, like I said earlier, the instructions for how to engage and participate in the hearing. And we provided a number of resources for people to be able to do that. And what I didn't say earlier that is important to mention now is that for any hearing that is going forward, whether it's a motion or whatever the reason for the hearing, we do have housing counseling service providers in every hearing. And that is another way that we're able to make sure that tenants receive the resources and information that they need for either legal service assistance or financial assistance through DC Stay. And I think right now ERAP funds may be limited, but we do have counselors in every hearing to assist with people connecting to those resources if they're needed.
Terrific. Thank you. Cristobal, do you want me to keep going with questions, or do you want to ask anything from the chat?
Yeah, so I have a couple of questions from the chat. The first one would be probably both from Ms. White and Chief Deputy Byraw. Are the marshals going to be scheduling and overseeing the eviction exceptions, which kind of piggybacks on what Joel was just talking about?
Any evictions that take place, and I'll defer to Sebastian to add anything, but I do know that all legal evictions that take place in the District of Columbia must be overseen by the U.S. Marshals.
That is correct. We will oversee those evictions. That is correct. Always.
Outstanding, thank you. Sorry. One other question dealing with evictions from the chat. If belongings are not put on the street, where are they put, and is there a cost associated to that for the tenants, to the panel in general?
So
No property put on the street.
that's like I said, there's no property put on the street. They could work that out with the landlord. I believe there's a time frame, but that is something we can't really talk about because it's a legal matter. So like I said, the best way for them to do it is discuss it with the landlord, and the landlord, I guess, can advise them on how to proceed, and that would be the easiest way for them to resolve that issue.
Understood. Ms. White, any?
I was just going to say that there is information online, and I can send you the website after this call for you to share out and make it available to others. But tenants do have the property when an eviction occurs. Property is not set out on the street like Sebastian already shared, and the property must remain in that address, in that location for a certain amount of time. And then afterwards, I believe it's within 10 days, the tenant must coordinate and the landlord must cooperate for the tenant to obtain their belongings. After that expired time, then the landlord can remove the property. They're free to dispose of it after that specified period of time. And I want to refrain from quoting the time because I don't want to misstate any information on the call, but I can share it with you after this call.
Understood. Thank you so much, Ms. White. Joel, would you like to ask another question, Joel?
I would. Thank you. Let's see. Which one? There's so many. Let me ask, in general, we heard a great presentations on the current law and the protections that are going to continue and be phased out between now and January. And I'd like a little back and forth, starting with Amanda on what is it that the council, DC government should be doing during the council recess, and then looking forward to the council coming back into session. I bet there's already a wish list, Amanda, on your part for further action that the council should consider taking to maximize our eviction protections for tenants in the district.
Yeah, absolutely. The way I have been thinking about it myself is like things I think the council needs to do to continue dealing with the emergency that's like right in front of our face, the eviction emergency right in front of our face, and then also longer term planning to deal with what has long been an affordability crisis in DC and long been a displacement crisis in the district, because that obviously compounded and made the eviction crisis we're facing now worse than it should have ever been. And so to me, looking forward, I think, and I think Ram spoke to this a lot, is looking forward, thinking about a lot of the things that are in this emergency law that really need to get codified and made permanent. Things like the $600 limit on cases, things like making sure tenants have 30 days notice of a court date, not just 7. I'm trying to think. There was additional requirements added and things that to be included in notices to cure or quit, so tenants can connect to resources and attorneys that can help them defend themselves in court. And I think all of that is really important. I think we need to look at our eviction law generally and ensure that, like, all of these protections that we realized in this moment are more important than ever are actually important always and are part of our permanent legislation in the city. But I also think that sort of responding to this crisis means responding to the affordability crisis that has long been in our city. That means looking, legal aid as part of the Reclaim Rent Control Coalition. We think rent control loopholes need to be closed. There needs to be more protections for tenants against extraordinary rent increases. The council voted, in my opinion, took a historic vote to increase taxes to increase the supply of subsidized, deeply affordable housing in this city. And that is the sort of thing that the council needs to continue to do and to continue to look at to make sure that in the future, if we, God forbid, are ever faced with a similar crisis, we are more fortified. We're a stronger city. All of our residents, regardless of income, are protected, and hopefully don't face what I worry we are facing, which is an eviction crisis.
Great. I guess I would throw that question also to the council staffers in terms of what your bosses or the council generally might already be thinking about. Maya, for instance, mentioned that she and the council are going to be keeping an eye on how well these very specific notices work and whether they work and how improvements might need to happen based on the experience over the next several months. But the more general question would be, what is the sort of thinking in terms of further steps that might be needed in terms of eviction protections generally to make sure that this cliff that we're all very anxiously trying to avoid doesn't happen? And Maya, I think I'll start with you on that.
Sure. I mean, one of the things that we're looking at and hopeful about is some of the funding that has come through in the budget for an expanded eviction diversion program. There has been an access to justice initiative for civil legal services. And that same program will be doing some work to help coordinate between legal services and financial assistance and mediation and any other sorts of entities with resources that a tenant might be able to access. So we had looked at places like Philadelphia and parts of Minnesota in thinking about doing that sort of combined approach to eviction prevention, but didn't want to do anything that made accessing those resources in a combined fashion or having mediation come first be mandatory, because it's a little new here, so we'll be watching to see what that program looks like as it gets off the ground. There's certainly more to do as well, just to make sure that we do hit a good balance where, the rental market and the supply of rental housing is available and affordable here, and that property owners have what they need to be able to keep it in good shape, but that we're ultimately remembering that it's also a home for the tenants who live there, and finding ways to make sure that an owner can get exactly what they need with the least possible risk of a tenant losing their home. So I'll just kind of leave it there for me.
Blaine, do you want to add to that?
Sure. I think the only thing I would add, I mean, the investments that the council is making in eviction diversion and civil legal aid are great. And I think we'll all be watching those carefully. One thing that I know all of our council members are very focused on too, though, is making sure that this emergency rental assistance money actually gets out the door quicker. And I know that that's something that everybody on this panel and folks watching are very interested in. Tenants need it, and they need it sooner rather than later. So I think we're going to continue to press the executive to make sure that that's happening. And if there needs to be any further tweaks to the law or anything like that that we need to do in terms of getting that funding out the door, then I think that's something that we'll keep an eye on. One of the changes we made in the law that I didn't mention was that we put in a requirement for the executive to allow housing providers to apply on behalf of tenants through the portal. They can help tenants apply on paper, but we wanted to give them the option to apply on behalf of tenants through the portal with the tenant's signature or written consent, because there are jurisdictions that are doing that right now, and they're having a lot more success in getting that funding out the door because of it. And then, yeah, I think just generally too, I think we're all going to be watching sort of the course of the COVID pandemic to see, you know, what needs to be done once we get back from recess, because we don't want to be in a situation where things get worse and then, you know, non-payment cases or other cases that maybe don't need to move right away if the metrics are really bad start up. So I think we'll all be keeping track of that as well.
So if I may.
Yeah, I was going to go to you next, Ram.
So this moment does present a very kind of interesting and perhaps unprecedented, you know, like opportunity in the conversation that we're having, because it's essentially like a reset moment, you know. And I wasn't at the committee in the months and years preceding the public health emergency, when there was so much upward pressure on rents and people were literally weeping in pain, you know, from the rate at which rents were just skyrocketing all across the city. And that phenomenon, I mean, it was like putting a fire out because everything has been put on hold. And now, as we come out of the pandemic, I mean, we really, I think, have an opportunity to have this discussion anew. And so the elephant in the room that, you know, we haven't been talking about is clearly whether or not we can expand rent stabilization in this city, you know. And that was the conversation that was raging right before the pandemic hit. And it is a conversation that we need to get back into, but maybe in a sort of in this new context of what might that look like. So we've set the stage for that by putting in place a moratorium on the certificates of assurance, which gives us a pause, and it gives us some time to think about, you know, whether we can repeal this obscure provision of the law that effectively prevents any expansion of our rent stabilization, you know, our rent stabilization system, and hopefully opens the door to how we begin to talk about expanding rent stabilization again. We also now have an opportunity to talk about strengthening our TOPA protections, as I alluded to in my presentation. And we probably really need to do that. And we took a small step in that direction by putting in place and funding a 2-year moratorium on voluntary agreements, which had been a favorite tool of abuse, you know, for developers when they were engaging in these TOPA deals. And we've put a stop to that, and, you know, setting the stage for TOPA reform, I mean, VA reform, to end abuse of voluntary agreements and maybe put an end to them altogether. But we still need to have that conversation. And I think that occurs in the context of looking at strengthening TOPA. So rent stabilization, TOPA reform, those are two major opportunities for conversation about long-term improvements. And then I just want to point out one very kind of interesting matter, and that is we've got 20% vacancy rates at our public housing properties. That is an outrage when you've got an affordable housing crisis and a homelessness crisis in your city. That is simply unacceptable that we've got 20% of our inventory out of service because we have not maintained them and repaired them to the degree that we need to. So great kudos to the chairman for topping up the repairs and maintenance budget for the housing authority. And we are looking at ways of holding the housing authority's feet to the fire to get on the ball about bringing back online these vacant units. It's completely unacceptable in the middle of an affordable housing crisis and a homelessness crisis to have 20% vacancy rates at our public housing properties. So we will be getting on that stick. And then speaking of that topic, and this is one that Alyssa Silverman has been particularly consistent about, not just maintaining the supply of deeply affordable housing in the city, but actually increasing the supply of deeply affordable housing in the city, so that when we take deeply affordable inventory out of service and then seek to replace it with these development deals or whatever you want to call them, that we're not just level of effort, that we look at ways to increase the supply and preserve community and not just, feel like we've done our job by setting aside the exact number of units that we've eliminated, but otherwise building, completely changing the nature, the character of neighborhoods and not involving the people who live in them in those development activities. And that just brings up my last point, which is you all saw that probably the centerpiece of the housing of our accomplishments in this budget in terms of the housing budget was a $400 million investment in the Housing Production Trust Fund, accompanied by a reform of the voucher system, the local rent supplement program, that allows us to maybe take some innovative approaches toward creating affordable housing, and then in that context, continuing to subsidize through the use of vouchers, deeply affordable units. But this is it's a development approach to creating affordable housing, which can sound like an oxymoron, like does the development approach to creating affordable housing, it can be done, but it has to be done right. I think the voucher policy and Maya and the Human Services Committee did an excellent job, really, of increasing the accountability of the vouchers that are being used for permanent supportive housing and other emergency housing for very low income individuals. I think we've come a long way this year in increasing the accountability of those systems. But this is now becoming a major stream of revenue going out into the community. A major way of subsidizing affordability in our community now is through vouchers. And once you award vouchers, you never take them away. So the amount of money that we spend on vouchers only grows year after year. And it starts to become a significant expenditure. It probably should be accompanied by a conversation about appropriate taxation or how you create, revenue streams to maintain and grow that kind of funding. And then also looking at how the vouchers are actually spent in the community. That is something that we really need to think deeply about. Are we spending our vouchers wisely when we spend more for housing in certain parts of the neighborhood than we do in other parts of the city? Is that really an optimal use of voucher dollars? I mean, should we be spending $2,400 for a 2-bedroom in Ward 3, but only $2,000 for a 2-bedroom in Ward 7? Is that fair? Is that right? Is that the right way to spend voucher dollars? I don't think we know the answers to those questions. These are deep and heavy questions that we really need to kind of get into in order to address what Amanda has raised, which is we got to take advantage of this kind of reset that the pandemic coming out of the pandemic represents to go deeply into some of these issues.
Absolutely. So, and
Welcome. Sorry, let me ask just one yes or no question of Ram, you were just alluded to the VA moratorium that is funded in the budget, and I believe that means that the 2-year moratorium takes effect perhaps when the Budget Support Act takes effect.
October 1 is my understanding.
Okay, I just wanted to nail that one. So there will be, thanks to the VA moratorium was funded, and that's going to take effect when the budget takes effect on October 1st. Thank you, panelists. All that was terrific. We appreciate it. Cristobal, sorry to
not at all. Not at all. Thank you. So 2 last questions dealing with Stay DC for Mr. Malik. The first one is, does a tenant need to apply for Stay DC if the landlord has already applied? And then the next question, which is, it's a twofer. So the next one is, several people in the chat box have been asking if there's electronic versions of the Stay DC flyers for them to post in Spanish and English in their building. Malik, the floor is yours for the last 2 questions.
Sure. So can you repeat that first one about the tenant and landlord?
Sure. Does a tenant need to apply to Stay DC if the landlord has already applied? On the
So let me, I'll get the exact, but it's my understanding that the tenant would have to essentially sign off. So I think we're going back to that thing where obviously the tenant can do an application and get paid, but the landlord has to have some sort of certification or sign off from the tenant. And I believe that's the same. So there would have to be some sort of kind of certification that even if the landlord started the application, that the tenant certifies that it's actually correct. And then for the second part, I'll make sure to email over all of the translated flyers and all of the languages that are represented on the website as well, electronically to you, Cristobal, and please share those far and wide.
Outstanding. Thank you very much, Malik. With that, on behalf of the Chief Tenant Advocate for the District of Columbia, Johannes Reeve, as well as the entire Office of the Tenant Advocate, we would like to thank the panelists and everybody present. It's really contingent on all of us, on OTA, our brother and sister government agencies, community organizations, and stakeholders in general, to keep the greater DC tenant community well informed of their rights, and this way help to keep individuals and households in their homes and avoid eviction. Please share the important information that we have shared today with your friends, your family, and neighbors. And importantly, if you need help paying rent or utilities, please go to stay.dc.gov or contact the phone numbers on the screen. And if you need legal assistance, contact the LNT Legal Action Network at 202-780-2575 and or the tenant hotline of the District of Columbia Office of the Tenant Advocate at 202-719-6560. With that, this concludes this evening's event. Thank you very much, and take care. Thank you. Okey-dokey. Okay, I think we're Nicole, outstanding. Yeah, we're good.